When is probate necessary? So there's a misconception in Washington state that all estates require a probate to be settled. That's not essentially true. If someone has a small probate, small estate that's, let's say, $100,000 or less, a lot of times they can get away without having to do a full-on probate and file a small estate affidavit. Additionally, it also depends on the type of assets a person has, if they have real property, and it also depends on how that real property is held by that person. Is it held solely by the decedent's name, so the title of the property is only in the person's name who passed away, or is it held with some kind of right of survivorship? For example, there have been some cases where we had a decedent and they were the only ones that had the name on the property, and that required a full probate because now we have to go through and get someone appointed, and then action can be taken on that property. Contrarily, we've also had folks when a spouse passes away and they have a joint right to survivorship of that property, and that's how that property is held between the spouses. When one spouse passes away, the other one usually takes over and has title to the rest of the ownership of that property. Additionally, one concern or one thing to think about is if you're a business owner or a business owner passes away and they have some kind of outstanding debts, whether in their business or in their personal life, that is probably going to require probate because formal claims are required to be filed within the probate court to be paid out of that decedent's remaining estate. Even when probate is necessary, understanding some of the terminology and the language really helps. So in the next video, we'll go through some of the terminology and actually explain what it means and what the differences are. Thank you.